Let's talk about how and why fiduciary duties protect directors. Remember, fiduciary duties are imposed on directors ostensibly to protect the corporation and protect the shareholders from director and executive officer misconduct. But fiduciary duty standards are very protective of directors. Directors will only be liable for the most egregious breaches of their fiduciary duties. Now, why might that be the case? Well, the argument is that this is what shareholders want. Shareholders want fiduciary duties that are highly protective of directors and executive officers, at least on an ex ante basis. Because the fiduciary duties are protective of directors and officers have enough leeway, enough flexibility to make business decisions that involve appropriate business risk without the fear of being second guessed, without the fear that they will be liable to the corporation for any type of damages that the corporation suffers for the failure of the transaction. Let's talk about situations where a director or officer will have a conflict of interest with the corporation. This is our standard. A director or officer has a conflict of interest, is engaged in self-dealing, if the director or officer has a material financial interest in the transaction that would reasonably be expected to impair her objectivity. All right, so this involves self-dealing or some sort of commission/kickback. Let's look at the common fact patterns of self-dealing. The first fact pattern is one that involves direct self-dealing. It's where the corporation enters into a transaction with one of its directors or executive officers. So imagine I am a director of our corporation and I sell a plot of land to our corporation. That is a case of direct self-dealing. The second example is an example of indirect self-dealing, where the corporation enters into a transaction with one of the director's close relatives. Once again, in that situation, we would consider the director to be engaged in self-dealing. Now, you might ask yourself, how close a relative does this need to be? Well, it really depends on your jurisdiction. The Revised Model Business Corporation Act has a provision that goes through this in detail. I think the basic idea is that we still have to go back to our original standard, and is this a relationship that would reasonably be expected to impair the objectivity of the director? Our next fact pattern is where the corporation enters into a transaction with some entity where the director has a large or material financial interest. So for example, if I am the shareholder of an LLC, but I'm also the director of our corporation, and our corporation enters into a transaction with the LLC, I am engaged in self-dealing. I am the shareholder of the LLC, and therefore I have a material interest in the transaction. Now, naturally, we have to ask ourselves the nature of the transaction. Is it a large transaction? We also have to ask ourselves, how much of the LLC do I own? Do I only own a small percentage of the LLC, or do I own a large percentage of the LLC? Why? Because we go back to our general standard. Is this a material financial interest that would reasonably be expected to impair my objectivity? Finally, another case of indirect self-dealing is where the corporation enters into a transaction with the entity where the director of the corporation is also a director or executive officer of the entity. So if we have Corporation A and Corporation B, and they are entering into a transaction, and I'm a director on both boards of directors of each of these corporations, then I am engaged in self-dealing. I'm engaged in self-dealing from the perspective of Corporation B. I'm also engaged in self-dealing from the perspective of Corporation A. All right, so if we have a conflict of interest transaction a director or officer might be liable for a breach of the duty of loyalty, but she can escape liability for her breach of her duty of loyalty if she can show that the transaction was fair to the corporation. When we talk about fairness in this context, we're talking about substantive fairness and procedural fairness. And usually it's referred to as fair price, that is substantive fairness, and procedural fairness, fair dealing. The whole idea is that if I'm a director and I engaged in some sort of self-dealing transaction with the corporation, I will not be liable if I can show that the corporation got a good deal. They got a fair price in this transaction. And when I negotiated the transaction and when I dealt with the corporation in this transaction, I dealt with the corporation fairly. Now, you might ask, if the corporation got a fair price, why do we care if there was fair dealing? Why do we care if there was procedural fairness? Well, there's really two answers to this. Number one, was the transaction something that the corporation desired or was necessary for the corporation? So the corporation might get a fair price, for example, for a plot of land, but if the corporation didn't need the plot of land, then the transaction was still not fair to the corporation. So procedural fairness, one of the things it's getting at making sure that the transaction was one that was desired by the corporation or was necessary for the corporation. Secondly, procedural fairness, fair dealing, is also a check on fair price. Think about fair price of any type of transaction. There's going to be a range of fair prices. And if you are dealing on an arm's length basis, you're trying to get a fair price that is closer to the range of a low price for you if you're paying the money, or a high price for you if you're receiving the money in the transaction. The only way we can ensure that you are getting the best deal, the best fair price in a range of fair prices, is if there was fair dealing in the transaction. All right. Let's talk about ratification of conflict of interest transaction. So we said that if I'm a director or executive officer and I engage in some sort of conflict of interest transaction with the corporation, I can escape liability for a breach of the duty of loyalty if I can prove the transaction was fair to the corporation, right? Which is a high burden for me to prove. I might be able to prove it, but it's a high burden for me to prove. Or alternatively, I can show that the transaction was ratified or sanitized, is another way we can put it, right? So what type of ratification or sanitization are we seeing? Well, there's board ratification and there is shareholder ratification. What this means is that either before or after the transaction, the board approved the transaction knowing that it was a conflict of interest transaction, or before or after the transaction, the shareholders approved the transaction even though they knew it was a conflict of interest transaction, right? If I'm a director and I disclose that I have a conflict of interest in this transaction, and either the board or the shareholders say, you know what, this is a good transaction for us anyway, then I should not be liable to the corporation for self-dealing, for a breach of my fiduciary duty of loyalty. So let's look at the details of ratification. So if we have board ratification, we want approval of the transaction by the other directors. And what does that mean by other directors? Well, the directors who are not conflicted in the transaction, by the disinterested, independent directors. So the directors not only need to be disinterested in the sense that they also do not have some sort of conflict of interest in the transaction that they are approving, but they are independent, which means they are not dominated, controlled by, or beholden to any of the directors that have a conflict of interest in the transaction. And finally, we want to see that these directors, these disinterested and independent directors, approve the transaction after full disclosure from the directors who had a conflict of interest, right? This whole process should make sense to you. Imagine you're a director on a corporate board and you have a conflict of interest in this transaction. What should you do? Well, you should tell the other directors that you have a conflict of interest in this transaction and let them decide whether we enter into the transaction. You should recuse yourself, right, if we use a judicial term. And the whole idea is that if you go through this process and then one of the shareholders sues you for breach of the duty of loyalty, you point and you say, listen, they thought it was a good transaction. I wasn't involved in the decision, so you can't sue me for self-dealing. You have to apply the business judgment rule to the decision of the directors who were disinterested, independent, and fully informed. Now, there might be a situation where a majority of the directors are conflicted in the transaction, and then it would be difficult to get board ratification or board sanitization. So you get shareholder ratification or shareholder sanitization. And once again, in this case, we're looking for approval of the transaction by disinterested, independent shareholders after they receive full disclosure from the conflicted directors. The only slight difference in this case is when we're talking about disinterested shareholders, basically we're talking about shares that are not owned by directors or executive officers who are conflicted in the transaction. Naturally, directors or executive officers often hold shares in the corporations on which they serve as directors or executive officers, and if they are conflicted, when we ask for shareholder ratification, we will not count their shares in the ratification process. All right, continuing our discussion of ratification of conflict of interest transactions, there is an alternate possibility that you need to consider. So our original possibility, our original standard was that a director or officer will not be liable for conflict of interest if she can show board ratification or shareholder ratification. But there is an alternate that is possible, and that is that the plaintiff shareholder will have an opportunity to prove the transaction is fair, even if there was, to prove that the transaction was unfair to the corporation, even though we did have board ratification or sanitization. So in our original standard, if the director or officer that has a conflict of interest shows there is board ratification or shareholder ratification, then the director or officer will not be liable to the corporation for a breach of her duty of loyalty. In some jurisdictions, even if the director or officer that has a conflict of interest shows board ratification or shareholder ratification, the shareholder plaintiff still gets another bite at the apple. The shareholder plaintiff will now have an opportunity to prove the transaction was unfair to the corporation. Some people call this a shifting burden test, and the whole idea is that the director with the conflict of interest has the burden to show board ratification or shareholder ratification, and once the defendant director does show board ratification or shareholder ratification, now the burden shifts back to the shareholder plaintiff who is suing for a breach of duty of loyalty. The burden shifts back to that shareholder plaintiff to show that the transaction was unfair to the corporation. If the shareholder plaintiff can show that the transaction was unfair to the corporation, then the defendant directors will be liable to the corporation for breach of their fiduciary duties. This is probably a minority approach. All right. In our ratification process, remember we talked about conflict of interest transaction where we either have board ratification or shareholder ratification of the transaction. One of our elements was full disclosure. So, for example, we have board ratification of a conflict of interest transaction by disinterested directors or disinterested shareholders, independent directors or shareholders, after they received full disclosure from the conflicted director. So what type of disclosures must the conflicted director provide to the board of directors or to the shareholders so that we have a valid ratification or sanitization of this conflict of interest transaction? Well, first, the conflicted director or officer must disclose the nature of the conflict, right? And this should make sense to you. We're considering a transaction, I'm conflicted in the transaction, and I tell the board of directors what my conflict is, right? And then the board of directors says, well, despite your conflict, we think this is a good transaction for the corporation, and so we're going to enter into it anyway, even though you might benefit from it. Secondly, I, as the conflicted director or officer, must disclose all material information to the board of directors or to the shareholders, right? The whole idea here is that I have a fiduciary duty to the corporation even though I am conflicted in this transaction. And since I have a fiduciary duty to the corporation, I cannot have an advantage of information over the corporation. Imagine we entered into this transaction on an arm's length basis, that I was not in a fiduciary duty relationship to the corporation. Well, then I can have an informational advantage to the corporation. I can engage in negotiations with the corporation on an arm's length basis. In other words, if there's information I have that's material to the transaction, I do not have to disclose that to the corporation because I am not in a fiduciary relationship with the corporation or the shareholders. But because I am a director, even though I have a conflict of interest, and even though we're having the board of directors, the other directors, or the shareholders ratify this transaction, I still stand in a fiduciary duty relationship with the corporation. And as such, I cannot have an informational advantage to, over the corporation. In other words, I have to disclose everything that I know. So there are certain things that contract law would require me to disclose. But if I'm dealing with an action where I am and a director of that corporation, and these two corporations enter into a transaction, well, now you can see my trouble is that I have a fiduciary duty to both corporations, which really means I have a fiduciary duty not to disclose information. So when I am put in the position of trying to get a good ratification, and I know I can't have an informational advantage, there's some information I cannot disclose about the transaction because of my fiduciary duty to each of the corporations not to disclose. And in that instance, I will not be required to disclose that type of information. The second exception is that I will not have to disclose my reserve price. So imagine I enter into a transaction with the corporation and I serve as a director on this corporation, and I'm going to sell a piece of land to the corporation. I have to disclose all information I have about this piece of land to the corporation. The one thing I don't have to disclose is my reserve price. What's the lowest price I am willing to accept for this piece of land? I do not have to disclose that, right? And once again, if we reverse the situation and I was buying a plot of land from the corporation, I would not have to disclose the highest price I'm willing to pay. Other than that, I have to disclose all material information I have about the transaction if I am a director or executive officer and I am engaged in a self-dealing transaction with the corporation. All right. let's talk about disinterested directors as defendants. Now, we've already seen that if a director or executive officer has a conflict of interest transaction and the shareholders find out about it, the shareholders will sue the director or officer for a breach of her duty of loyalty. That's clear. But shareholder plaintiffs will sue all of the directors. And the question is, what cause of action do you use to sue the disinterested directors? Clearly, when we're suing the conflicted director, we're going to use a duty of loyalty claim. But what cause of action will we use when we sue the disinterested directors? All right, so there are several possible situations. Number one, maybe the disinterested directors approve the transaction knowing of the conflict. Maybe the disinterested directors approved the transaction and they did not know of the conflict of interest. Or maybe the directors never approved the transaction. It was one of those transactions where we didn't require director approval and the directors did not know of the conflict. Finally, we might have a situation where the disinterested directors approved the transaction in a situation where they were not really independent, where they were dominated, controlled by, or beholden to the conflicted directors. All right, so let's talk about a situation where the disinterested directors approved the transaction even though they knew one of the directors or one of the executive officers had a conflict of interest, right? This is the sanitization process. They sanitized or ratified the transaction even though there was a conflict of interest. You are a shareholder plaintiff. What cause of action do you have against the disinterested directors? Well, you don't have a duty of loyalty claim if you think about it, because we said they're disinterested, so there is no conflict of interest for the disinterested directors. So your best bet is a duty of care claim, that they engaged in a reckless decision-making process, or a duty of good faith claim, that they intended to harm the corporation, probably not, or that they failed to act in disregard of a duty to act. Maybe. You can see that the duty of care claim and the duty of good faith claim is a high burden for the plaintiff in the ratification context. When you sue the disinterested directors because you're unhappy that they approved this self-dealing transaction, you're probably going to lose, right? It's going to be difficult for you to show that the defendant directors engaged in a reckless decision-making process. If you are representing the board of directors in a conflict of interest transaction, you want to make sure that they engage in a careful decision-making process to protect them from any type of fiduciary duty claim. So what about the situation where the disinterested directors approved the transaction, but they did not know that one of the directors or one of the executive officers was conflicted in the transaction? Well, you might have a duty of care claim. You might say that the directors or executive officers did not engage in a careful decision-making process. They engaged in a grossly negligent or reckless decision-making process. They did not inform themselves. You might also make a duty of oversight or duty to monitor claim. You can see this as a failure to catch another director or an executive officer engaged in misconduct. And we said that the failure to catch or detect one of the directors, executive officers, or employees of the corporation's misconduct, that usually falls under the rubric of the duty to monitor. Once again, probably not a very good claim. The shareholder plaintiff is probably going to lose because both the duty of care and both the duty of oversight are very protective of the board of directors. What if the board of directors never approved the transaction? It's some sort of transaction that doesn't normally come before the board of directors. And it would only come before the board of directors because it is some sort of conflict of interest transaction. The board doesn't know that it's a conflict of interest transaction. It falls through the cracks. and the board never has a chance to approve it, and they did not know of the conflict. Well, that's a duty of oversight claim. The whole idea is that, listen, board, you should have had some sort of mechanism to catch these type of transactions, catch these type of conflict of interest transactions so that it would come to the board for approval, but it did not, and therefore you breached your duty of oversight, you breached your duty to monitor. Once again, the duty to monitor the standard of liability is very protective of directors, so this would be a hard claim for the shareholder plaintiff to prove. And finally, we have the situation where our disinterested directors approved the conflict of interest transaction, knowing of the conflict, but they were dominated by or beholding to the conflicted directors or executive officers, right? So in other words, the ratification was done by disinterested, but the directors were not independent, and they need to be independent. What type of cause of action would you use against the disinterested directors who were dominated or controlled by or not independent from the conflicted director or conflicted executive officer? Well, we could do a duty of care claim. We can try and argue that they engaged in some sort of reckless decision-making process. Duty of good faith, right? In this case, probably not intent to harm the corporation, but you might have a good argument that they failed to act in conscious disregard of a duty to act, right? They knew they were dominated and they should have treated this transaction differently. Or we can argue that they were so dominated or so beholden to the conflicted director that they were actually conflicted themselves. And then we would use a duty of loyalty claim against them. Let's talk about the duty of loyalty claim that is often called usurping a corporate opportunity. The idea is that there is some sort of business opportunity out there, and the director or executive officer takes the opportunity for herself, and she does not let the corporation have it, right? The issue is, can the director take the business opportunity? Must she allow the corporation to have first crack at the opportunity? The idea that the corporation should get the first chance at the opportunity is a strong one because the director or executive officer is in a fiduciary relationship with the corporation, and as such, she must put the interests of the corporation ahead of her own. The corporate opportunity claim is a duty of loyalty claim, and as such, the conflicted director or executive officer can escape liability for breaching her duty of loyalty if she can show that it was fair for her to take the opportunity, right, a fairness test, or that her taking of the opportunity was ratified by disinterested, independent directors or shareholders. Let's talk about the fairness test in the corporate opportunity context, right? The issue is, was it fair for the director or officer to take the business opportunity for herself without allowing the corporation to have the first opportunity at it? Naturally, fairness is a vague term, and so it's very fact-specific, but courts generally consider the following factors when determining if it was fair for the director or executive officer to take the opportunity, the business opportunity for herself. Number one, expectancy. Did our corporation have an expectancy in the transaction or in the opportunity? Was the corporation somehow planning for this opportunity? Were they engaging in negotiations for this opportunity? Were they discussing this opportunity? Did they have any expectancy in the business opportunity at all? Is the opportunity within the corporation's line of business? If the corporation is in one line of business and the opportunity is another line of business, that would lean towards saying that it was fair for the director or executive officer to take the opportunity. Did the opportunity come to the director or executive officer in her individual capacity? Right? Did someone contact her outside of her role with the corporation, or did it come in her corporate capacity? Did she find out about the opportunity through her role with the corporation as a director or executive officer? Has the corporation rejected the opportunity in the past? If the corporation has already rejected the opportunity, that would lean towards us deciding that it was fair for the director or executive officer to take the opportunity for himself. Now, this is not dispositive of the matter. There are many times where a corporation might reject an opportunity, and then a month later they might say, oh, we want that opportunity. So just because the corporation has rejected it, that in and of itself is not dispositive of the matter. We have to consider all of these factors. Corporate incapacity. If the business opportunity was in the corporation's line of business, but for some reason, financial or otherwise, the corporation is not able to take advantage of the opportunity, then that would cut towards us saying that it was fair for the director or executive officer to take the business opportunity for herself. And finally, if the director or executive officer takes the opportunity, will she be in direct competition with the corporation? Remember, the director or executive officer has a fiduciary duty to the corporation, which includes non-competition. If the director or executive officer takes this opportunity and will then be in direct competition with the corporation, that would lean towards us saying that this was not an opportunity that was fair for the director or executive officer to take. All right, let's talk about ratification in the context of corporate opportunity. This is pretty simple, right? So we have a director or executive officer, and there is some sort of business opportunity. What can she do to protect herself if she wants to take this business opportunity? The answer is she can get either ratification from the board of directors, right? The board of directors can approve her taking the transaction, or the shareholders. When will we get shareholder ratification? Well, normally we get shareholder ratification where more than one director, several directors, or a majority of the directors are going to be in a conflict of interest. A majority of the directors are taking this corporate or business opportunity. So just like we saw in the self-dealing context, ratification or sanitization, if you prefer, requires approval of the transaction by disinterested and independent directors or disinterested and independent shareholders after they've been fully informed. Full information requires the director or executive officer who wants the business opportunity to disclose all the material information that she has about the opportunity. Naturally, if the board of directors or the shareholders are disinterested, independent, and they've received full disclosure from the director who wants to take the opportunity, if they approve the transaction after this process, the court is going to say that it was fair for the director or executive officer to take that opportunity for herself. Finally, let's talk about the exculpation clause in the context of these duty of loyalty claims. Remember, the law provides, and this is, we have Delaware law and the Revised Model Business Corporation Act, that a corporation can put in its articles of incorporation a provision that exculpates directors for breaching their fiduciary duties. Now, importantly, you'll see as we look at this that they have exceptions, and the Delaware exception starts with provided that. The Revised Model Business Corporation Act provision starts the exceptions with except for. As you read through those, you'll see that the import of those exceptions is that you cannot have an exculpation clause that exculpates directors for breaches of duty of loyalty, which would include the self-dealing, conflict of interest, the kickback, and the corporate opportunity, among other fact patterns that we might say are duty of loyalty claims. Remember also that the exculpation clause cannot exculpate executive officers at all. It can exculpate directors for breaches of fiduciary duties, but generally only for the fiduciary duty of care, not for the fiduciary duty of loyalty.